Right, we have already our panelists in studio with us. I introduced earlier to you Professor Nyong'o, who's the governor of Kisumu. Also, we do have with us the member of parliament from Ndaragua, that is Honorable Jeremiah Kioni, and also the global leader of Kenya Diaspora Alliance. This is Dr. Shem Ochuodho, eagerly waiting for Junet Mohammed, who is the director of elections in ODM, and also Gladys Bostrele to join us much later in the course of the program. But we want also, before we go to a panelist, to also set the tone for the conversation about the contentious issue about, of course, the tenure of the president, that is President Uhuru Kenyatta right now. As far as we know, the Attorney General also has come to make it clear that yes, he's still the legitimate presidency and there's nothing like a caretaker government that will happen in between. Let's listen in.
The President of the Republic of Kenya continues to enjoy full executive authority, including the powers bestowed on him as the Commander-in-Chief of the Defense Forces.
All right, let's listen now from what you have to say. Professor Anyang, let's begin with you first of all on this contentious issue right now as far as the presidency is concerned. Are we having an incumbent president, or what will happen after the October 26th?
Well, good morning, Debarl.
Good morning to you.
Good morning, my colleagues.
Good morning, Prof.
Well, you know, I think there's a common saying that exceptional situations call for exceptional measures. The Constitution provides for the election of the president, the swearing in of the president, and all that. We never envisaged, I think, a situation where a case, of course we envisage a situation where a case in court,
yes,
and election is nullified as it was, and a new one is elected, and the time period is provided for. I think the exceptional circumstance here is where the time period is provided for 60 days, and now we have set it for election for 26th of October, 4 days before the time expires, and then we find out what we need to do before that election is held on the 26th of October may not be done. I think those are the facts of the case. If those things are not done, and the election is not held on the 26th of October, and 60 days pass, what then happens? I think rather than the Attorney General just asserting that the President continues to be President with executive powers, I think he should apply his mind to the Constitution,
yes,
and the best practices elsewhere, and perhaps what happens in the Commonwealth, and find out what we need to do, because we have a parliament sitting, and whether the parliament will be the right body to make a decision or law to govern us in case that happens, I don't know. I have not applied my mind effectively on this matter, but at least I know the facts of the case. And my point is that rather than just asserting the president continues to be executive, even if that expires, especially if it is not envisaged in the present constitution and the law, then I think those exceptional circumstances require that we decide and discuss what to do, which perhaps I would request my colleagues to contribute to, because I myself am not sure whether the Attorney General is right. I don't know what is right. But I think it's a kind of a crisis we need to look into.
So there's not much clarity that we have as far as this particular part of the Constitution is concerned, because of course we have the Attorney General speaking on one side, we have the principal, especially Wetangula, coming forth and saying, of course, that is not the truth. What the Attorney General is saying, that President Uhuru right now is a caretaker president.
Well, if you look at, let me just make maybe one point before Jeremiah makes a point. If you look at the terms of the president, Article 142, which says very clearly, the president shall hold office for a term beginning on the date on which the president was sworn in, and ending when the person next elected in accordance with Article 136 2A is sworn in. A person shall not hold office as president for more than 2 terms. Okay. If you go to 136.2a, 136.2a says the following. An election of the president will be held on the same day as a general election of members members of parliament, being the second Tuesday in August in every 5th year. So that is obvious. That one we know. I don't think it tells us anything particularly new. So the point is that I had a hunch that if you just look at the Constitution alone at the moment, and then 146 says the vacancy in the office of the president. The office of the president shall become vacant if the holder of office A, dies, which is not the case, B, resigns in writing address to the Speaker of the National Assembly, or C, otherwise ceases to hold office under Article 144 or 145 or under any other provision of this Constitution. Now, 144 and 145 don't make our situation any better.
Yeah, that's impeachment.
Yeah, which is impeachment. So any other provision of this Constitution I have not seen. I don't know whether Jeremiah you've seen it.
No, I think Debarl and what Prof is pointing out is he has pointed out to Article 142. And let me say this: when we were in Naivasha, the thinking then, if I can recall, and I remember Senator Ndaragua was also there. The thinking was that we should ensure that there is no vacuum that is created. There is no time when this country is not under the hands of a president. And I think that informed the Article 142, which Prof, the governor of Kisumu, has just led to us, that the president ceases being the president when he hands over to another president. So I do not see a situation where, in my mind, I don't see where a caretaker government comes in. I don't see a situation where we are in a crisis per se. But we have the 60 days, and it is important for us to that we ensure that the elections are held within the 60 days. Because I don't think it's in the interest of any of us in the political realm to get the country into a crisis. So whatever it is that we want done, we must make sure that it is done within the 60 days. And for that reason, we cannot insist on issues that cannot be achieved within the time frame that we have been given by the courts. But in the event that then we have issues that we want to resolve outside that 60 days, I think then we will be guided by that Article 142, that we will have to continue resolving them until we have another president. And I don't see any court of law, including the Supreme Court, because it's also a court of law, that would want to guide us otherwise. Because in so doing, you get a country in a crisis, and you do not make a constitution so that we get ourselves into a crisis. We enact constitutions and laws so that we remain orderly. And when interpreting the constitution and even the pieces of legislation from the assembly, you interpret them for good order, not for disorder, not to create damage, for public good, not the reverse.
So,
and again, you don't just read the constitution in this, you read the whole document and see what was the intention of this constitution.
So as it is right now, it's not really shrouded in ambiguity?
I don't find it, there's no, in my mind, there's no ambiguity. And I think if we want, if we do not want the president to be there longer than perhaps people think, unless and until we have a legitimate way of, or until the date of election, the best thing to do is to allow the elections to be held as called out by IBC. But if we have put conditions that are not achievable within the 60 days, he will continue being in office.
Let's
and again, without any limitation to his powers.
Let's hear from Dr. Shem Ochuodho.
Debarl, allow me to congratulate our athletes in Berlin.
Yes.
Having said that, I have an issue with Kenyans who feel or believe or wish that we have a presidential election beyond the 60-day deadline that's set in the Constitution. I think in that case we will be treading very dangerous waters. In terms of what the Honorable Attorney General said, I agree with him in one respect and I don't agree with him in the other. When he says we have a full-time president, he's right. The president is full-time. He's not temporary or acting. But when he says he still has full executive powers, that's where I disagree. Because Article 134 probably is what my colleagues were looking at, exercise of presidential powers during temporary incumbency. There are certain things that the president cannot do now. For example, he cannot appoint judges of the superior courts. That's Article 134 sub Article 2. The powers referred to in the clause are he cannot nominate or appoint the judges of. He can also not nominate or appoint any other public officer who this constitutional legislation requires to be appointed by the president, and so on. He cannot declare power of mercy. So to say that he has got full executive power is, in my view, misleading. But yes, he's full-time. The rest of the functions, other than those which the Constitution bars him from having, he has. But having said that, Debarl, I really, personally, and I took time to go through the Supreme Court full judgment, I really think we need to do everything to ensure that we comply both with the Constitution as well as with what the Supreme Court did say. I do know that people may say, okay, in certain situations you can put aside the Constitution, but that would be a very dangerous ground, because then what will be guiding us? So my take, I do know that people have talked of the Constitution can be amended, you can have, like we had in the 2007 crisis, there was the agreement that the National Accord, which was considered to be above the Constitution, I really would be very jittery as to why we need to go that route. Mm-hmm. So yes, in terms of the president continuing, of course the president continues to be until that day that a new president is elected and sworn in. Mm-hmm. So that doesn't matter how long it takes.
But allow me to point out that
yes.
What Shem seems to be bringing out at Article 134 is okay, is correct, but he is reading words into the Constitution that are not there. Because the words are not that he cannot. Just in the event that we even hold that Article 134 comes into play, then we must read the words properly. And it says that where the president is absent or incapacitated or at other times as contemplated at Article 147.3, the words that have been used is may not. Those are the operative words. The word is may. It's not even shall. So you may want to say that he is temporary, but the word is not. The word is he may. We are not going to get into a situation of war and then start playing around with words. Mm-hmm. We want a president who can order that we protect our territory properly. And that is why that word was used that way. It still allows him to use those powers, to have all those powers if need does arise. So there is no vacuum. There is no, you're not going to find that gap that some people are looking for. And that's why I'm saying you do not read just one article or one part of an article, and then it helps you understand the whole of it. And I want to repeat again, if you look at it and remember where we were before the 2010, we had a situation where Parliament would be dissolved 3 months prior to a general election. And during that time, there were no members of Parliament or nobody was holding office other than the president because he had been elected there before. But this constitution, now, Parliament remains, members of Parliament remain members of Parliament until the date of the next election, general election. And the intention was to ensure that we don't have these gaps, lacunas, that can get us ourselves in a crisis when, in the event of a crisis during that time. So that is the spirit of the Constitution, and I think it's the same spirit that we must read into the issues of the president. You are not going to look for, you're not going to get a place where we have no president in this country, or where you negotiate outside an election or an elective process for the presidency.
But I think, let me just defend Shem on this one. I think Shem's interpretation of Article 134, to me, excuse me, Jeremiah, is actually correct. Because the word may here cautions the president on issues that are not as critical as war. I think war is a different thing than appointing public officers. It says a person who holds the office of president or who is authorized in terms of this constitution to exercise the powers of the president during the period commencing on the date of the first vote in a presidential election and ending when the newly elected president assumes office, or while the president is absent or incapacitated, or at other times contemplated in Article 147(3), may not exercise the powers of the president. May, yeah, but yes, you see, may not exercise the powers of the president or specified in Clause 2.
Clause 2.
Okay. The powers referred to in Clause 1 are the nomination or appointment of the judges of the superior courts, the nomination or appointment of any other public officer whom this constitution legislation requires the president to appoint. For example, the nomination appointment of cabinet secretaries.
Yeah.
He may not nominate
Sure.
during this period of transition.
And my argument, Prof, is this.
But when it comes to critical issues, I mean, the word may has to be interpreted very carefully. I agree with you that if the crisis is facing a war, then of course to tell the president that he cannot do something can put the country in jeopardy. But it's something like nominating just a cabinet secretary.
And I want to tell I want to take it to where we are now, where we have the IBC. In the event that it is one of the nomination of any public officer whom the constitution or registration requires the president to appoint, I would bring the IBC under that P. In the event that we have no commissioners in the IBC, we are not going to allow the country to run into a crisis. When that is where you now exercise the word may, he must step in.
But then there's parliament.
Yes, and for parliament, but you see, parliament can't just finish it. It is finished by the president. And that is where I think the word may, if you allow me to finish, that's where I think the word may is used so that you don't get yourself in a crisis and you cannot get out of it.
Jeremiah, I used to have an English teacher. If you asked him, sir, can I come or can I go? He would say, yes, you can, but you may not. We need to take a greater distinction here. May can be used in many contexts. In that case where he says you can, but you may not, what he means that you are able to go, but you are not permitted to go. I think that's the manner in which may is being used here. Secondly, I think Mheshimiwa Jeremiah wasn't considering sufficiently the sub-article 1A. During the period commencing the date of first vote, it's actually not even part B, which is applicable in our case. We are talking of a case, we've gone through an election. The election process is still ongoing. It has started. From that day, 8th August, there are powers. I wouldn't say the president is caretaker. I would be hesitant because that word is not used in the constitution. But I know for a fact that it's not right to say he has got full, all executive powers. The Constitution says, because this is not put here for decoration purposes, even the spirit of the Constitution, I mean, and if it was a question of choosing the president having the option whether to exercise them or not, they wouldn't even appear here in the first place. But the fact that the crafters of this Constitution put certain things that the president cannot do, like the appointments.
Yes.
And in fact, just to answer the point Mheshimiwa Jeremiah was talking about, if today Chebukati, anything happened to him, we would have a big problem, a major problem. I'm glad that Parliament is talking of amending, some members of Parliament are talking of amending the provision that requires that the chair of the commission, the IBC, must be a lawyer, must be eligible to be a judge of the Supreme Court. Basically saying that he must be a lawyer, senior lawyer for that matter. In a case where the only commissioner in the IBC is, that's a lawyer, is the chair, there would be a lacuna if anything happened to Chebukati for now. So to that extent, even the president wouldn't have the power to appoint, even if Parliament had to approve, go through the processes of vetting a new chair of the commission, there would be a constitutional problem here.
In the event of what he has just said, if Chebukati was, for one reason or another, unable to perform his duties, the same constitution says that the vice chair takes over. And he takes over, or she takes over, with her qualifications. We will
Even
then
if
look
she's
around.
not a lawyer.
Oh,
because
this constitution allows you.
Which article,
I will give it to you. It is in when you go to the Constitutional Commissions, the provisions are there. We are not in a law class. You know, at times we must make sure that we don't crowd the public by reading articles, and we have come to help them understand some of these things. It is, I get tired when you are in a forum that is meant to be listened to by Wajiko, and you turn it to a legal class. You know, it's like you are litigating. But we can do that. But let me say this.
So
let me say this.
It's actually you to actually take the cookie from the high shelf to the low shelf for us to actually crack it.
Let me even put it aside. Common sense. When the chairman is not there, the vice chair steps in.
So
if it was intended that the vice chair
must be a lawyer.
It would have been provided.
Yes.
For both.
And that is the constitution provision to ensure that there is continuity. There is no law that is crafted in a manner that you bring people to a deadlock.
All right, I want to get
144A, 134A, where he was saying that, and this is where he's talking about the temporary incumbency. The argument that will be there, and we'll be ready to advance it, is that then we go to the wording of the Supreme Court judgment. They said, what happened on the presidential vote on the 8th of August was invalid, null and void. And we will argue that then nothing happened. The president reverted to the 7th of August when he had the full powers. And these are arguments that you continue having. And the intention is that this constitution does not get you to a dead end. It was never the intention of those who crafted it. And if there was such an intention, then we would go back and blame them.
Yeah, but if also we have clauses and prepositions, maybe like may, you know, it is also
in law,
everyone is bound to read his own interpretation into that.
I'll tell you why I did not want to go to the English teacher. When you are in a law class, when the word may is used, there is discretion. When it's there's no discretion.
Yeah, that's true. That's true.
Yes, so
it has nothing to do with the English teacher. It is still helps.
But isn't that now in the discretion where we have all, you know, the tripping wires? Because if we have discretion and then it is upon your own discretion, it is upon my own discretion how I want to interpret it.
In this regard, Jeremiah is right, because if I say, tell to Jeremiah, may you live long, I'm not saying he shall live long.
Yes.
I'm just wishing that he lives long. I'm not giving an edict. So when it's saying the Constitution may, it means the person responsible should weigh the circumstances, may choose a woman for this position. It means if there is a group of people who are competent, there is no woman, then you will not make a mistake by choosing a man. But you are advised to go out of your way to look for a woman for that position. So I think in law, the word may gives a lot of discretion. I agree with that.
And this as you read them in the presidency, they're still the same provisions that you read in the governor's office. Because these are things that can happen.
Thank you.
You don't...
Thank you. We need to go on a short break now.
Okay, sure.
Right, but also before we go there, maybe as a segue to what we'll be discussing, of course, this is in context with what we're having this morning. There was an article also yesterday in The Standard written by the constitutional lawyer, Kibe Mungai, and tucked away also these words. I wish I had them on my screen, but I'll just read them. It says, since the presidential election held on the 8th of August was invalidated by the Supreme Court, President Kenyatta's term will continue until the person next elected during the fresh presidential election, now scheduled to be held on the 26th of October, is sworn in. The question, however, arises, what if the fresh presidential election ordered by the Supreme Court, pursuant to Article 140, subsection 3, fails to take place for whatever reason? And of course, we can see there are a lot of demands coming from NASA as well. So what if that really happens? What next? And of course, we will seek to pursue that, of course, and bring some clarity to it as well on the other side of a break. Don't go away. Much more coming up on the other side of a break. You're watching Decision 2017. This is a point. Right, we continue the discussion here on This is a Point, Decision 2017. Of course, I'm holding court this morning with Proffesor Anyang Nyong'o, who is the governor of Kisumu. Also, we do have with us Jeremiah Kioni, who is a member of parliament from Ndaragua. Also, we do have with us